A 20-year-old precedent was overturned by the Alaska Supreme Court Friday in its 4-1 ruling that Alaska Native Tribal Consortiums, which provide health care for both natives and non-natives, are largely immune from civil lawsuits in state court unless those consortiums waive their immunity. Under the decision, immunity is now established by a 5-part test already used by some federal courts. Previously, state judges used a simpler test that examined only whether a consortium was financially separated from its member tribes. Fairbanks attorney Jim Davis of the Northern Justice Project says he believes thousands of consortium employees now have no legal recourse in cases of sexual harassment, discrimination, or wage theft unless the consortium waived its immunity in their employment contract, even though they can still be sued in federal court. The new ruling says that federal decisions make it clear that in 2004, the Alaska Supreme Court was wrong when it determined that financial insulation was the key test in deciding if a consortium was legally an arm of its member tribes and should share in its sovereign immunity. Instead, judges should examine the purpose of a consortium, the way it was created and is controlled, the intent, and the financial relationship between the consortium and its member tribes. In overturning its prior precedent, the court determined not only that circumstances had changed, but changing its interpretation would, quote, result in more good than harm. Reporting from Juneau for Seward Public Radio, I'm Dorene Lorenz.